Case on this morning's docket, case number 111540, State of Kansas v. Jones.
To please the court, I would ask the court to reserve 3 minutes for rebuttal, please.
Three
Yes.
minutes is granted.
Yes, sir. In considering this case, I think it's important to understand the circumstance that Mr. Jones found himself to be in regarding this very serious crime, and the question of whether or not the court should have inserted himself into whether or not there was bona fide reasons of doubt as to the competency of Mr. Jones. And that manifested itself in the hearing May 22nd, 2013. And his circumstances were that he was 17 years old, he was waived over to adult status, he had a 10th grade education, and from everything I can discern from the proceedings was somewhat limited in his intellectual capacity to certainly understand what was swirling around him. And
I have a transcript of that hearing. Would you point me to where you think that he's not capable of understanding the nature of his charges or assisting in his defense? It just seems to me, even for a 17-year-old, he's answering the court's questions. I don't know where a trial judge who's making this inquiry or having this dialogue with your client would suspect he's not competent.
Well, I think it's because of what he said during the inquiry by the judge. And this hearing started out to be something totally different than what it ended up being.
Well, he expressed some dissatisfaction with his lawyer. He
did.
Articulated what it was.
But the key point to me...
Where does that lend itself to? This person is not competent.
Well...
And warrants an evaluation.
Well, certainly our position is that it warrants further inquiry because of what he said, and it's a short phrase, but I think it speaks volumes. He says, I don't understand. I don't understand. And we have raised an analogous case in State versus Foster. And I think that's an important case because it's very close to the situation here with Mr. Jones. And that is, in the Foster case, although this court found that there was no merit to the issue of the question of whether or not the court should have, on its own volition, instituted a competency proceeding, or at least further inquiry about competency. And in that particular case, and the reason I say it's close, because they both used that same language before the court and says, I don't understand. Now, there's differences, obviously, because in the Foster case, the whole issue arose in voir dire versus here it arose in a proceeding, in a hearing. And in the Foster case, there were two sets of facts that Foster case turned on. One was that there was very good communication, according to this court and the evidence that was presented, between Mr. Foster and his counsel. That certainly was not the case here. In fact, there was a discussion about whether or not his attorney, Mr. Jones' attorney, should be allowed to be withdrawn because there was just simply no communication between them, and that was admitted by his lawyer. It was certainly conceded by Mr. Jones at the time. And he said he understood after a long, lengthy, and apparently successful explanation by the court of what was going on in the voir dire proceedings. Again, that is not the case with Mr. Jones. He says, I don't understand what's going on, basically. And based on that, I think the court, our position is that the court should have stopped and inquired further, what don't you understand? What is it that you don't understand about these proceedings? And at least had a colloquy between himself and Mr. Jones about what was going on. Unfortunately, the court kind of lost it here, and I'm not making a judgment on that because, Mr. Jones has been a pain in the anatomy throughout this whole case. He's, litigious and so forth and so on. But that doesn't detract from the point of whether or not the judge had bona fide evidence in front of him that at least he should have inquired further as to whether this young man, 17 years old, limited education, really understood what was going on and why.
The vehicle that you're bringing this claim is under an illegal sentence, is that right?
That was the original pro se motion.
I assume you've reviewed State v. Donaldson,
Yes.
recent case. Would you distinguish that case from what is before us now? It seems to me that's right on point, or as close as possible to being on point, that this is not the means by which you bring this claim.
Well, State versus Donaldson, as I recall, the facts in that case was sufficiently different from what we have here. If you could ask a more direct question, Justice Rosen, tell me what
Go ahead.
I was going to quote from Donaldson, if that's appropriate.
That's very appropriate, right?
In a recent decision, State versus Ford, we held that a KSA 22-3504 motion to correct an illegal sentence is not an appropriate vehicle for challenging a conviction based upon an alleged violation of the competency to stand trial statute, KSA 22-3302. Thus, we affirm the district court's summary denial of Donaldson's motion to correct an illegal sentence as being the correct result.
The only way I can argue against that, Justice Rosen, is to say to you, if it is construed, this is a pro se motion, so if you construe it in the best light possible to Mr. Jones, not so much what the title of the motion was, but the content of the motion. I think clearly in that motion, he asked the court to do something, and he asked the court to reverse his sentence and his conviction because he just simply didn't understand and should have been the subject matter of a competency hearing.
So you're suggesting it should be read as a 1507?
Well, yes, and there's certainly merit to that in terms of what the case law says. State versus Kelly, for one.
Didn't that happen here? Didn't the trial court then say, yes, I'm going to be even extra cautious and treat this as a 60-1507?
Yes.
Denied that, and that was taken to the Court of Appeals and denied also.
Yes.
Okay.
I can't argue against that, Judge. The facts are the facts. But what I'm asking this court is to consider whether or not it was appropriate for the judge to at least inquire further into his competency, just based on the fact that he says he didn't know what was going on. And although the court berates him on during the hearing, and again, I'm not judging that, but certainly it raises the implication that maybe this young man didn't know, and at least the court should have at that point, because that's bona fide evidence, if there was ever bona fide evidence of doubt as to whether he was competent to stand trial. That's our position.
Any further presentation?
No, Judge, thank you.
Any more questions? Thank you, counsel.
Thank you.
Good morning, Justices. May it please the court. The state's position is simply that we recognize that a court has a duty to, when sufficient evidence is presented or before the court, that it recognizes, the court recognizes that they have a duty that they should inquire further. But our position in this case is very simply that there was nothing before Judge Seavey in this case that would have led him to believe that the elements of the competency statute, that there was a reason to believe that because of mental disease or deficiency, that this person didn't understand the proceedings or couldn't aid his attorney. I think it's obvious from a reading of the complete transcript there that Judge Seavey believed that what was happening was that this defendant didn't like what was going on and was being obstinate, hard-headed, whatever you want to call it. But that's certainly a lot different than because of mental disease or defect that he didn't understand. And that's what the standard is. I think that's what Judge Seavey looked at as he had his discussion with this defendant. Every time a defendant, and if I had a nickel for every defendant who said, "I don't understand," in court, I would have retired a few years ago. But that every time a defendant says, "I don't understand," that it shouldn't automatically turn into, "Stop, let's go have a competency examination." I think you have to look at the totality of that proceeding that happened and see that the totality of it is that it's not that he didn't understand, is that he didn't want to understand. He didn't like the way that things were going on. When the district court is presented with such a situation, I don't believe the statute for competency requires the court at that time to stop the proceedings and then hold some sort of competency proceedings. That's simply the state's position on this. I'll stand for questions on it.
Any more questions? I see none. Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
We will waive our 3-minute rebuttal, Chief Justice.
Any questions?
Mr. Wells, I have a question. Clarify your argument. You're saying that a defendant saying, "I don't understand," is sufficient to support the court finding that there's reason to believe that the defendant is incompetent to stand trial? That factual finding is a predicate to staying the proceedings and going further.
Well, the case law says that, or if there's bona fide evidence, that the court should inquire further. That's our position. And in terms of whether or not that's sufficient, I would again point out the Foster case, although given and conceded that he had numerous, Mr. Foster had numerous psychiatric evaluations. That's different because there was never a competency issue raised in this case regarding Mr. Jones. But the fact of the matter is that during Foster, he said, "I don't understand." And those are almost exact words that Mr. Jones uttered. And so that's our position, Justice Johnson.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.